Hello, it's 1 p.m. We're back after a lunch break. Mr. Tremaine, you still have 30 minutes remaining in your cross-exam time if you'd like.
Thank you, Madam Hearing Officer. Good afternoon, Ms. Felix. I will be quite brief. I think I only have 3 more questions, so we'll move right along. Ms. Felix, before we recessed, I was asking you about concerns with OCD implementation of the proposed rule and referring you to parts of OCD's enforcement rules, analogous enforcement rules. So I want to follow up on that. Are you aware of any instance where OCD refused to extend for good cause the initial 30-day informal resolution period for an NOV?
I am not aware.
And are you aware that since the new NOV rule went into effect, informal resolution is routinely extended to much longer than 30 days?
I was not aware of that.
If you were to follow up on this testimony with like discussions with perhaps OCD's legal director and such, and confirm those statements, would that assuage any of your concerns regarding implementation of the 30-day response period for the presumption of no beneficial use?
Right now, without knowing and being able to follow up on that, can't answer that I would be persuaded, but I am happy to follow up and dive into that information.
Thank you. Did you hear Mr. Powell's rebuttal regarding the OCD Form C-145?
Yes, I did.
And just to clarify, after hearing that rebuttal, do you maintain your position regarding the C-145?
So, yes, because the statement of that 25% is still currently on the C-145.
Do you dispute that the threshold for the 25% threshold that you're referring to is encoded in 19.15.99 for operator registration?
Without looking at it, I can't answer that and tell you I dispute that right now.
Sure. I don't want to belabor that point. We'll address it in closing. I do want to ask you a couple questions kind of about the process going forward. And before I ask you the questions, I would just want to make very clear that I am not asking you any specific questions about the inner workings of NMOGA or discussions or any confidential information. But I think there have been numerous representations during this hearing that the commission could expect NMOGA to engage in some way going forward. Is that fair?
That is fair.
Okay. And you had testified earlier that during the pendency of this case, you had not been authorized to discuss or negotiate certain points about the proposal at the time of those proposed meetings. Is that correct?
That is correct. And there's negotiations and sitting down and discussing and talking through is something that I want to make sure that we all know. It could be apples, tomatoes, right? But we are very open, like what we've said through the hearing, and we maintain that to having those discussions.
Negotiations and talks can be characterized differently.
Yeah.
I don't dispute that, and I'm not trying to pin you to any particular thing. And like I said, I'm not asking you to articulate a particular revised position on the stand live. But I do want to clarify just so the commission and OCD has reasonable expectations that as of today, have you achieved a consensus among NMOGA members that you believe is sufficient to allow NMOGA to prepare a red line response to the petition?
So we do have a red line response already based off consensus of membership that was submitted as Mr. Sporich's testimony. Is that what you were asking?
Well, I'm asking about a red line with different content as implied by the course of the hearing.
Oh, based off what we've learned on the hearing.
Absolutely.
So what we what we know today. And I think what would be fair to all of us is to let all parties, witnesses continue to lay out their case. And then, yes, I feel very strongly that we could get NMOGA membership in a positioned up. It'll be a lot of work. I've already said that, but so that we can engage in those discussions as the commission desires.
And do you, as of today, have approval to either sit down and meet or negotiate with OCD and the petitioner based on the course of the hearing and the content of the petition?
As of today, no. Where we are is finish letting all parties lay out their case so that we have all the facts to consider, but we are willing and able to have those discussions after.
Okay. The reason I'm asking, belaboring this point, I believe was addressed by Commissioner Ampoma earlier during the hearing, which is that typically in a hearing such as this, when we close a record, parties are going to have to submit their final red lines, all of that stuff, and closing arguments. And I'm not going to say, guess how long the commission gives, but that's usually 30, 60 days. So I'm trying to get a sense from you whether NMOGA is going to be at the table during that period of time to allow the parties to submit closings in the normal course. That was kind of all statement and preface, but I'm asking you if you can confirm or deny that.
No, I confirm that your assessment of what the process would need to look like would be correct, and that timing would be correct based on my understanding from council.
Okay, but you believe that we'll be having those discussions with enough time to submit closings?
I believe that would have to be our goal. Yes, sir.
Okay, thank you. Not trying to belabor that. I pass the witness. Very much appreciated.
Thank you, Mr. Tremaine. Mr. Birnoff, do you have questions of Ms. Felix?
Thank you, Madam Hearing Officer. I do. And good afternoon, Ms. Felix. Good to see you. So let me start by asking you about a reference in your testimony to the 180-day timeframe that's contained in the petitioner's proposal for marginal wells. Do your members, your member companies, receive any special shut-in lease approvals from the State Land Office?
Yes, sir.
And are those shut-ins for reasons like lack of takeaway capacity?
Yes, sir.
Do those shut-in reasons also include, for example, an ongoing nearby frac and the land office wanting to avoid environmental harms from a frac hit?
Yes, sir.
Okay, and what about joint discussions with the land office for particular development to maximize reservoir depletion? Is that also a reason for land office shut-ins?
Yes, sir. And that's to the point that I've made earlier, that we have to consider the lease basis when discussing these provisions.
Okay, and what are there are other reasons in addition to the examples that I just mentioned and that you just confirmed where the State Land Office grants shut-ins, right?
Yes, sir.
And the land office also grants statutory extensions to rework wells, is that right?
That is correct. Yes, sir.
Ms. Felix, do you think that it would be prudent for any rule to include approvals of extensions that are authorized by the land office, at least with respect to wells that are on state trust land, in consideration of any 180-day time limit when considering marginal wells?
Yes, sir. I think it would be prudent for the commission to consider all owners of minerals, including the State Land Office, to ensure that they're not harmed in any way.
Okay. Now, Ms. Felix, if a person or a company, an operator operates wells, let's say in the state of Texas, and leaves all of their wells inactive and unplugged, do you think that the Oil Conservation Division should know that that operator wasn't operating responsibly in Texas?
So Yes, I do think they should know. And I do think that the process to become okay, I'm assuming you're talking about a new operator coming into the state. That's correct?
We can start with
Yeah,
that for sure.
okay. So the new operator would have to apply for and become a registered business qualified to do business in the state and successfully secure their O-grid and all show demonstration of their bonding and such, which effectively is what the vetting process is today.
What about if it's an incumbent operator, not a new operator, somebody who's already operating in New Mexico and is also operating in another state and leaves behind a number of unaddressed compliance problems like unplugged wells that are inactive in that other state? Is that something that the OCD should be able to learn about and know about?
Yes, that is. And to what degree and framework that is shaped up to, I don't have an answer for that.
Okay. Okay. Now, you mentioned earlier having some concerns regarding the Oil Conservation Division rejecting operator changes based on the 25% threshold, right?
So not rejecting them, I was just providing context that the current 25% provision is already included on the C-145 form today and has been since 2019, I believe, 2019, 2017.
Okay. If somebody is affiliated with a company, and let's say the person, the individual, has a 25% interest in the company files for bankruptcy, or let's say has a bunch of non-compliant wells, do you think it's a liability to the state and the rec fund for that person, the individual, to just turn around and start a new company and forget about the wells from the old company?
Can you restate that? I'm sorry.
Sure. Let's
It was
take an
long.
example. No, I know it is a little long. We can break it up sort of into parts. If a person is affiliated with a company, let's say that that person has a 25% interest in the company. So far, so good, right?
Yes.
Okay. And then let's say that the company, the entity, uh, has a compliance problem, and we can define that here as leaving behind a bunch of inactive wells that the company doesn't plug. So far, so good?
So far, so good.
Okay, here's the question. Do you think that it's a liability to the state and to the rec fund for the person, the individual, to just turn around and start a new company and forget about the wells that are inactive and unplugged from the old company? Is that a concern for the state?
I'm going to object to this question in that it calls for speculation.
So Ms. Felix, if you can answer without speculating, that's great. Otherwise, just say so.
I would be giving a guess if I were to answer.
Well, I guess I'm asking, since you're a representative of an industry association that's obviously important to these proceedings, what is the association's position on whether it is okay or not okay? Although, let me phrase it in the most direct way possible. Is it okay, from NMOGA's point of view, for a person who is affiliated with a non-compliant company to turn around and start a new company and for that liability to be on the state of New Mexico? Is NMOGA okay with that?
So our mission is for the safe and responsible development of the resources in the state of New Mexico. If a person who is employed as an authorized agent for a company leaves a company to go start another company, I truly, and I'm totally like spitballing here, but how is the division going to follow and administer that? I would believe it would be on the company basis and not the person basis.
Well, fair enough. And I want to be clear, I'm not asking about line employees. I'm not asking about, a staff representative of a company. I'm talking about an individual who has an ownership interest in a company or who has a management position in a company. And I'm asking for NMOGA's perspective or position on whether it's acceptable for the state of New Mexico to hold liability in an instance where that person basically walks away and starts a new company and starts operating a bunch of new wells. That's my question.
I got you. And I would just respond in the same that NMOGA's mission and our members' mission is for the safe and responsible operation and development of gas in the state. When you bring in, managers and such, our industry, as great and wide as it is, managers and management staff do go from company to company. So I do think it would be a very hard way to track managers at that level and not at the company level, which I'm not trying to degrade what you're asking. I do think it's important that, yes, the land office needs to know who's coming in and who's coming out. But at the individual level, I don't have in my head a good framework of how that would work other than outside the company.
Oh, okay. And let me ask it a different way. Does it enhance or the opposite, detract from the safe and responsible development of oil and gas resources in New Mexico for individuals to be able to walk away from liabilities and continue operating in the state of New Mexico with impunity?
I kind of feel like that's a legal question.
Well, NMOGA has taken a lot of positions in this rulemaking proceeding, and NMOGA has, through you and other witnesses who are not attorneys, offered opinions on a number of policy questions. And I'm asking not for reference to any body of law, but just for NMOGA's perspective or policy views on the question that I posed. Is it a good idea from your members' perspective, from the organization's perspective, to allow individuals to create liability, let's say in the form of unplugged inactive wells, walk away from that, and then keep operating under a new corporate name?
No, it's not.
Thank you very much. I want to also ask you, Ms. Felix, you're aware from, I think, our dealings individually and probably also from your members that there are a number of NMOGA members who are state land office lessees who have plugged inactive wells that they have not themselves operated, right?
That is correct. Yes, sir.
Okay. So doesn't the 25% threshold, doesn't that actually benefit your members by taking liabilities that they are currently incurring on behalf of bad, defunct, disappeared operators and actually doing a better job of making sure that those liabilities go with the companies that are causing the problems?
Can you restate that? I'm sorry.
Yeah, I'm asking about the 25% threshold in the context of my prior question, right? So you agreed that you're aware that a number of NMOGA member companies at the state land office's behest plug wells that those companies are not themselves operating, right?
Correct.
Okay. And then, so I was asking, in light of that, doesn't the 25% threshold, doesn't that actually benefit NMOGA members in that individuals who are affiliated with or interested in bad operators and then basically are serial bad operators go on and start another company and continue to create compliance problems, that this threshold would help reduce that kind of serial bad behavior? Doesn't that benefit NMOGA's membership?
I honestly am not following the question, so I can't answer that. I'm not following it, sir.
Okay, isn't it to NMOGA's members' benefit to have a reduction in the number of non-compliant wells that are out there on, let's say, responsible NMOGA members' leases? Do you agree with that?
I think it's a benefit to anybody.
Including your members?
Yes.
Okay, thank you. I am ready to pass the witness, Madam Hearing Officer.
Thank you, Mr. Birnoff. Let's see, I don't believe we have Ms. Manassi. Mr. Maxwell, do you have questions of Ms. Felix?
No questions, Your Honor. Thank you.
Thank you, Mr. Rankin.
Madam Hearing Officer, no questions on my behalf. I appreciate it. Thank you.
Thank you. EOG is monitoring without questions. Mr. Cloutier.
Yes, Madam Hearing Officer, just a couple of questions. Good afternoon, Ms. Felix. I want to follow up on some of Mr. Birnoff's questioning. Are you aware of any concrete example of a major player in a company that abandoned wells in New Mexico or any other state forming a new company and coming into New Mexico to operate?
No, I'm not.
And you've been listening to these proceedings?
Yes, sir.
Have you heard any evidence presented of such a person?
No, sir.
All right, thank you.
Yes, sir.
All right, Mr. Suazo, do you have redirect?
Do. I need a second to pull up OCD's rebuttal exhibit 33.
All right.
Ms. Felix, are you familiar with the document on the screen, which is OCD's rebuttal exhibit 115?
Yes.
And do you understand that that lists operators who have not filed C-115s?
Yes.
Do you recognize any NMOGA members on that list?
Can you scroll down? And this is the same list, so it hasn't changed. So no, I do not.
Okay. In the hypotheticals presented by Mr. Birnoff, do you have any personal knowledge with respect to the 25% interest?
No.
Just a couple more questions against my better judgment. I'm not going to ask you about the discussions between NMOGA industry and applicants. But over the course of these proceedings, have you heard the request from the commissioners that industry provide feedback to this rulemaking?
Yes, I have.
And does Namoga intend to provide that feedback?
Yes, we do.
No further questions.
Thank you. Commissioner Ampoma, do you have questions of Ms. Felix?
Yeah, let me follow up from where Mr. Suazo left off. Thank you, Ms. Felix, for your testimony. I'm not going to go into any technical, just to see if there could be some consensus. So following up from where Mr. Suazo left off, so NIMOGA is going to provide the commission with some recommendations, but is it going to be in consultation with the applicant and then with OCD?
Based off what we've heard over the last 2 weeks and the urging of the commission, I believe that would be in the best interest, and that's what we intend to do.
I appreciate that.
Yes, sir.
And Mr. Sherman touched on that, so it really helped a lot. But with the timeline, do you have a fair idea as to the timeline that NIMOGA might need from the commission to be able to fulfill this responsibility? So
I want to be able to answer the question, but I would need to get some legal advice as to, I know the commission can do what you want, right? We would appreciate that the commission gives, you see a little head shaking, okay. We would appreciate that with the commission's urging, and I think this will just help all parties involved, that there is ample time built into the current scheduling schedule that's already out there. What that is, I can't even begin to tell you right now, Commissioner, but I think all of our attorneys in the room have some idea of how that could look for these discussions.
So it would be great. This one is to NIMOGA's counsel, if you can advise the commission, if that discussions could more or less, go on for us to have a fair idea on that.
Sure. Well, I think that at the conclusion of the proceeding, the parties are going to, discuss with the hearing officer what the post-hearing actions are going to be and what time frame they're going to take place over. I know that we're going to need time to get the transcripts from the proceeding, analyze those, and then, review all of the evidence that's on the record so that we can come forward with reasonable proposals. And that is what we intend to do based upon the parameters and timeframes agreed upon by the parties.
Thank you. And I thought we were very close until I heard from Mr. Sporich yesterday. That threw me off a lot. Thank you so much. I do not have any further questions.
Yes, sir. Thank you.
Thank you, Commissioner. Commissioner Bloom, do you have questions?
Yes, just a couple questions. Thank you. Good afternoon, Ms. Felix. Nice to see you.
Nice to see you.
Ms. Felix, you testified that companies make their budgets 5 to 10 years out, so it would be hard for companies to adjust to annual CPI, that is Consumer Price Index updates, correct?
That's correct. Different portfolios, different timeframes.
Okay. Rather than use CPI, and I believe Mr. Sporich spoke against that also, what if the commission set bond amounts at 5-year increments as part of this process right now? So, and I haven't looked at a compounding interest calculator, but generally over the past 20 years, inflation has been about 2.5%, or the past 30 years has been about 2.5%. Over the past 10 years, it's been a little higher because of the post-pandemic inflation at around 3% on average. But if we took a 2.5% inflation rate, by 2030, or I don't know if it would be 2033, when the next 5-year period would be up, we'd be at 168,000. That's 12.5%, not compounded, but it's my way of saying that the OCC could actually write in what the bonding amounts would be, if that would be beneficial or something we could consider. Any reaction to that?
I would think that, a consideration of a tiered approach in that manner, as you described, would be something that all parties could, consider and see how that works. I do think it would be beneficial for the open-mindedness to that.
That way we would have the bonds being updated every 5 years versus every year, correct?
Yes, sir.
Yeah. Would that be less cumbersome on companies?
I believe on companies and on OCD as well.
Okay, thank you. Something else I've seen, we haven't really discussed it here, but could it be a hardship for a company, particularly a smaller one, to have to put up $150,000 bond or bonds at nearly the same time during implementation in 2028, have to come up with perhaps a similar amount of money, you know, $50, $100, $150,000 to P&A a well?
You asked, I'm sorry, would you repeat?
Yeah, could it be a hardship for a company, particularly a smaller one, to have to put up a bond and at the same time be thinking about plugging that same well?
At the same time, if that's the current status of that well, yes.
Would it make sense, say at OCD, discretion for good operators, to let a bond or bonds be released if a company is in good standing with the OCD within some time period of plugging?
Yes, I believe that would be helpful.
No further questions. Thank you.
Thank you, sir.
Thank you. Chair Chang?
No questions from me. Thank you very much.
Thank you.
All right. Thank you very much, Ms. Felix.
Thank you.
Do we move now to IPANM's opening statement?
Sir, good afternoon, commissioners. IPANM appreciates the opportunity to participate in this rulemaking and appreciates your diligence. IPANM's going last, so we hope we get the same consideration as every other party, and I trust we will. IPANM is a trade association, a group of companies that participate exclusively in the upstream or exploration and production portion of the oil and gas business. We have overlap with NMOGA's membership, and we share virtually all the same concerns here, but my association doesn't have anyone participating in the midstream or downstream portions of the business. I do want to make one point on orphan wells very clear from IPANM's perspective. IPANM abhors the fact that there are orphan wells in New Mexico. It acknowledges that there are such wells, and it acknowledges that unfortunately it's going to happen again. I want to address the engagement issue first off. I do not accuse and do not ever intend to imply any bad faith on Ms. Fox's part, and she did reach out. But there was no scoping on this rulemaking that industry could participate in. It was sprung on us right before it was filed. We didn't have a chance to discuss how we would solve the problems that is the supposed target of this rulemaking, and that made it very difficult. Compounding that is, as Ms. Felix testified, it was deja vu all over again. IPANM engaged heavily in the process surrounding House Bill 133, which was a very similar bonding proposal. When that type of proposal was the central feature of the rulemaking and the division's rulemaking, it was impossible for IPANM to reach a consensus on any portion of the rulemaking because those provisions are existential to some of our members and crippling to others. And to be clear, applicants' evidence confirms that the proposed rulemaking is going to be damaging to our small operator members. By way of example only, Mr. Purvis testified in rebuttal that the rulemaking would impose, and I quote, painful costs for industry, close quote. And there were a number of exhibits presented that attempted to minimize basically my association's members' contributions to state production with the message, you're not going to miss them. The tenor of applicants' presentation here changed on, I think, the first day because they realized that they were effectively promoting underground waste by advocating these positions. But the evidence is there in their case, and it's a difficult thing for our membership. In his opening, Mr. Tremaine addressed the historic 95-5 split of industry plugging. That's in evidence through applicants. I understand that last year that was not the split, and I don't know the rest of Mr. Tremaine's objections, but it is in evidence. What Mr. Tremaine, I think, missed the point on, and that may be our fault too, is that we're not saying that we get an A because we get 95% of the wells plugged. That's not the point. The point is that most operators plug all their wells that need plugging. And that is measured in that statistic. They bat 1,000.
Madam Hearing Officer, I wanted to give Mr. Cloutier a moment to finish his thought, but I do have to object because he's making a closing argument, not an opening. He's referencing the proceedings of the hearing and my opening. We'll have that opportunity.
Madam Hearing Officer, I wanted to set the tone for what our case is going to be. And Commissioner Ampoma in particular, Mr. Powell as well, has been inviting a lot of engagement here. And I feel like I need to explain to the commission where we're coming from.
Okay. Thank you for your observation, Mr. Tremaine. Go ahead, Mr. Cloutier.
It's a group of bad actors, and the question came up, what is a bad actor? Unfortunately, they disappear from plugging and abandoning, and they're not around to answer the questions that all of us probably have on them. But I suspect it includes some people who maliciously plan to walk away and leave the state with it. I suspect it includes people who took too much money out of their companies and businesses, and there wasn't enough left at the end. I suspect there's some who never capitalized properly to begin with, and I suspect that there are some who just experienced some misfortune. But what industry objects is to a painful solution imposed on all for the sins of a few. Again, Mr. Tremaine used a traffic analogy in his opening, and I concede all analogies start to fail at some point if you pick at them, but I think this analogy fails pretty quickly. In his analogy, industry is a single driver that drives every day through the intersection at St. Francis and Cerrillos, and 95% of the time doesn't run a red light. Industry is not one driver. Industry is the entire stream of traffic in that analogy. And there are, in that analogy, some people who run red lights. Just like it would be unfair to have everyone driving through that intersection post a bond that is forfeit if they ever run a red light, industry views this proposal, and my members view this proposal as similarly unfair. Enforcement should be directed at the offenders. And we're going to talk about that. OCD may not be able to predict bad actors either. We're not in the regulator's seat, but there was clear testimony that I confirmed from Ms. Romero and from Mr. Powell that the people who are orphaning out there are repeat offenders of numerous OCD regulations. The OCD exhibit that Mr. Suazo just pulled up shows operators with state and fee wells that haven't been reporting production for 16 years. Applicants submitted Exhibit 8, which identified the wells that they thought were at risk because of no temporary abandonment regulation compliance. IPANM submits, and our witnesses will testify, that we don't need more regulations for these operators not to comply with. If the division wants to talk about how do we streamline enforcement for these problems, we're happy to sit down and talk about it. But the regulation's already there to enforce, and the violations are known. Our witnesses are going to talk about these commission's primary duties. And I don't mean to belabor the obvious, but to prevent waste and to protect correlative rights. This rulemaking and the evidence submitted in favor of this rulemaking is contrary to both duties. It's going to create economic waste by having operators who pose no apparent risk to the state to tie up capital in bonding. It will create waste by stranding otherwise recoverable hydrocarbons because some operators are going to choose to plug their otherwise economic wells instead of bonding them. We agree with Oxy's witnesses that it's going to cause plugging of wells that may have future beneficial uses or used for beneficial purposes. Applicants' witnesses essentially admit the underground waste and justify the rulemaking because in the scheme of things, it's not a significant percentage of annual production. Because production is going to be impaired, as our witnesses will testify, so will correlative rights. At the center of IPANM's position in this rulemaking is we think it's ineffective policy. I can see, and IPANM can see, that as commissioners of this commission, it's got to be frustrating to see orphaning of wells, and you have to have a desire to address the issue. Don't blame me at all. The fundamental problem we have with this proposal is that financial assurances are going to be bad policy because the people who post the financial assurances are going to be the operators who are plugging anyways. I was going to spend more time in my opening talking about the pretty poor history of bond recovery that's shown in Secretary Shelton's testimony to the LFC and the annual reclamation reports that both applicants and IPANM submitted. However, during the course of these proceedings, we learned that the OCD sent demand letters to 3 surety companies or surety companies for 3 different of the biggest offenders or frequent flyers on the orphan well list. I hope this is real change, but past history isn't that great. But this case, and applicants raise it and OCD cite it, is about, in the short and midterm, about 4,100 wells that the LFC identifies as being orphaned already, about to be orphaned, or at risk of being orphaned. In this rulemaking, we're presented what's supposed to be a data-driven solution, but there's no data-driven evidence. And our witnesses are going to testify that it's probably going to put people out of business, that this bonding is going to prevent wells from being orphaned. Mr. Purvis, when asked this question by me, said he didn't have any data, but pointed to Mr. R. Scott, my witnesses, IPANM's witnesses, exhibits. We'll address that with Mr. R. Scott. But interestingly, Mr. Peltz testified about several states that have raised financial assurance requirements in the past 15 years or so. IPANM asks you as commissioners to ask, where's the evidence from these states that these financial assurances protected against orphan wells? Where's the evidence that it helped the state collect money for wells it had to plug? When presenting the at-risk wells, and I can't remember if it was 33 or 32, Mr. Powell conceded that he didn't expect any of those wells to be bonded. Neither do we. We expect some of our members, and you'll hear from them, will testify that they'll try to bond, and I think others who will struggle. We admire Mr. Powell's optimism and Mr. Purvis's optimism that they hope bonding in the future will defer the cost of orphaned wells in New Mexico. But with the pain that's going to be submitted on IPANM members that we're going to articulate, I suggest to you that hope is not enough. I want to highlight a few things you're going to hear and not hear in IPANM's case. We have been accused of not having a data-driven case, guilty as charged. There are no databases for the sort of things that IPANM is going to present to you. How increased financial assurances will affect small companies, their transactions, their decisions on investing in existing wells, and their plugging decisions. You're going to have to hear that from the members, and it is anecdotal. We're a trade association. We don't have access to members proprietary data or financials unless a member agrees to share. And I've dealt with oil companies for almost 40 years. They don't even like complying with subpoenas for that information. You're going to hear operator stories about successes with low producing wells, from the purchases, workovers, and recompletions, and how significantly increased financial assurance requirements are going to create waste by disincentivizing these productive behaviors. You're going to hear from our technical witnesses about the difficulties that will exist in the surety market. We have a legal and industry combined expert who's going to talk about various problems that this rulemaking will create and those that it's not going to solve. And we'll present a corporate finance expert, Mr. Arscott, who will discuss the financial repercussions of this rule. Finally, as we've been looking at it, while I think the issues are very different and there is no question of motive, you're going to hear from some members that OCD Exhibit 16 doesn't accurately reflect data about their company. And I submit that exhibit is probably not ready for prime time. IPANM's been accused in this proceeding about not proposing a solution. That isn't true. IPM has been and still will propose a solution, but it's not one this commission can act upon. I'm not talking about the power. We've flogged the Rankin's rainbow and we've got motions to dismiss, but IPANM believes that the policy in this rulemaking should be the province of the legislature. But decades ago, independent producers worked with the legislatures to create the Reclamation Fund. That fund was created with an extraordinary matter, a new tax to which industry agreed, a form of severance tax that is imposed on and only on industry participants. In fact, every industry participant except for two, the state government and the federal government on their royalties, pay that tax on every molecule of hydrocarbon extracted and sold in the state of New Mexico. Unfortunately, in tougher economic times, that reclamation fund has been raided, which is our view, or if you want to use the technocrats' verb, swept, to balance the budget and used for other purposes. It's gone down to zero a few times. The tax statute that industry consented to is also changed so that most of that tax, the oil and gas conservation tax, is being directed to the general fund where it was never intended. IPANM has supported multiple bills over the years to increase funding to the Reclamation Fund by diverting all or more of that tax to its intended purpose. People probably won't like hearing it, but that's the only way these orphan wells are going to get plugged. In closing, I'm going to say two things, and you're going to hear this from members. We're happy to discuss with the divisions ideas how to address some of the concerns they've expressed in this rulemaking and let them consider those suggestions. But we don't believe that this rulemaking meaningfully addresses those concerns. Second, I will reiterate, IPANM's case is going to emphasize what applicants have already told you. This rule is going to create substantial economic pain for industry that's going to be borne disproportionately by smaller operators. It's going to create underground waste. It's going to create economic waste. We don't believe that hope is a sound basis for such policies with those effects. And we believe that the fundamental objects of this rulemaking should be rejected by the commission. Thank you for your time. And we're ready to call our first witness, Madam Hearing Officer. I believe David Mitchell is on the platform.
On the platform, Mr. Mitchell?
I'm not seeing a David Mitchell.
There is an
signed up, but-
Osage conference room.
Osage
Sorry.
conference room. I was just about to
Okay.
ask that. Okay,
Thank you.
Thank you, Ms. Tripp.
I will let them in.
Mr. Everhart, if you could pull up his brief PowerPoint? Good afternoon, Mr. Mitchell. Are you there?
All right, there we go. You hear me?
Yes, thank you. Mr. Mitchell, would you spell your first and last name for the transcript, please?
DAVIDMITCHELL.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Mr. Cloutier.
Mr. Mitchell, would you introduce yourself to the members of the commission, please, and tell them about your background and education?
My name's David Mitchell. I'm a mechanical engineer from the University of British Columbia. I've been working in the oil and gas industry for a little over 20 years for Transatlantic Petroleum and Longfellow Energy, and prior to that, Talisman Energy.
Thank you. You submitted direct testimony in this matter, correct?
I did.
And are there any changes or corrections to that testimony that you want to make?
There is one. I mean, at the time of my testimony, the definition of a marginal well was a well that would produce 10 barrels of oil equivalent per day and had to produce for 365 days a year. At that time, I think I quantified about 50 vertical wells that we have that would fall into that category. Since that time, I think the redefinition has been, I think 2.5 barrels of oil equivalent a day and 180 days per production per year, which would reduce that number to about 20.
Thank you. Would you briefly introduce the commission to the company that now employs you, Longfellow, and yeah.
Sure. So Longfellow Energy is actually the second generation of a company called Riata Energy, which was founded in 1985. That company became the company known as Sandridge today. And the founder of that company started Longfellow Energy in 2008. And we've been operating in majority of Texas, Oklahoma, and New Mexico for that period of time. We entered New Mexico in 2019 through a small acquisition and now operate about 100 wells in New Mexico.
Thank you. And could you explain to the commission the purpose of your testimony?
I'm here to sort of provide the impact of these rules on operators such as ourselves. We're a small operator in New Mexico, producing about 6,000 barrels of oil equivalent a day. So just to provide the operational and impacts associated with a company our size.
Are you here to testify about any other aspects of the rulemaking?
No.
You mentioned in your direct testimony the Loco Hills project in east of Artesia that Longfellow has. Can you tell the commission how long it took to put that together, how expensive, how many wells, those sort of details?
Sure. We started the project in 2019 through a small acquisition from Clayton Williams. That brought in about 45 vertical wells and the acreage associated with those wells. Over the next few years, we put together through also acquisitions of working interest or full ownership in a number of vertical wells across the township that we're predominantly operating in, just east of Artesia. Since we started drilling in 2020, we've drilled about 40 horizontal wells to date. We took the project from, at the time of the initial acquisition, about 200 barrels a day to today, a little over 6,000.
Thank you. Has Longfellow plugged any wells in New Mexico?
We plugged a well probably in the last 3 to 6 months. Is the one well we plugged recently.
Thank you. Do you have operations in other states?
We do. We have operations in Texas where we operate about 1,300 wells. And we have operations in Oklahoma where we have a small position. It's an exploration position.
How does this bonding proposal compare to the bonding you're required, say, in Texas?
So in Texas, we have a $2 million blanket bond for our wells that covers all 1,300 odd wells that we currently operate. I can't speak exactly to Oklahoma, but it's it's a nominal size project, and the bond there is quite nominal. Between the and now in New Mexico, we have a lot of different layers of bonding. We have bonding in our SWDs, excuse me, bonding on our surface uses on both federal and state lands and fee lands, and we have bonding on certain infrastructure that we own. So currently, the aggregated bond for the 100 wells we have in New Mexico is about 2.5 times the aggregated Texas bond we have for the 1,300 well operation.
Could you describe for the commission, well, first of all, let me just be clear. When you acquired the Loco Hills project from Clayton Williams, was there existing production that you're still operating?
Yes.
Right. And how were these some of the wells that you testified as qualify as marginal under the proposed rulemaking as you now understand it?
Yes.
Could you talk to the commission about the issues and how Longfellow goes about managing lower producing wells and the various considerations that go into that?
Okay. So like I said, we have about 20 wells that would be considered marginal today, but we probably have 50 wells that fall into a lower producing bucket. You know, when we look at our well set, we look at it as a program. And so when we take a look at our financials and cash flow on a group level and a well level, monthly and quarterly. And what we're trying to understand is both the break-even economics associated with each well and how we actively manage costs. Obviously, higher producing wells have higher costs, lower producing wells have much lower cost. And really, when we think about costs, it's important to understand the difference in types of costs. You know, you have fixed costs, which are more associated with your operation at large, and variable costs, which are much more tied to an individual well's production, proportional to an individual well production. An example of a variable cost is the chemical that you would put into a well, or the electricity that you would supply that well for operating the pumping unit, for example, where a fixed cost would be maybe the manpower associated with managing a part of the field and all of the infrastructure in place to do that. So we look at really our break-even economics on both total and variable cost basis. And as wells become marginal, the actual true cost impact to us of adding or subtracting one well is quite nominal. You can pump one of these vertical marginal wells for really just a few $100s a month because you're really, if I can say I can take a field of vertical wells, I can put one pumping route there associated with that field. And the cost of managing that operation, if it's 50 or 49 or 48 on a fixed basis, is really the same. It's really the variable cost, which is a very small percentage of the total cost that you're saving through adding or removing those vertical wells. So we look at it both ways, but that's sort of how we look at it in general.
I believe that in your direct testimony, you expressed a concern from Longfellow about the transfer provisions in the proposed rulemaking. Could you tell the commission what your concern is?
When you say transfer, I'm not sure. I fully
transfer of operatorship provisions.
Okay, sure. I mean, look, we buy our projects. They all develop in different ways, but for sure, one of the ways we grow our projects is through what we call bolt-on acquisitions. So we have an area of operations, and we will acquire assets in and around that area, so we can expand our operations without really building a new field operation. So we can roll that into the existing fixed cost structure that I described before. So in New Mexico, in the Loco Hills project, the majority of our position was put together through those types of acquisitions. If these, very recently, actually, we were looking at a package for acquisition that had about 300 vertical wells associated with it, as well as, but we were predominantly focused on, we buy these vertical wells, we're focused on the horizontal development associated with the lands that these wells are on, in and around. There was lots of development opportunity on this package, but it came with something approximating 300 vertical wells. And just the risk associated with these regulations and the cost burden that they would imply that could come into effect was enough for us to really step back from that process because of what we believe is the significant cost associated with these measures that are being proposed.
Thank you, Mr. Mitchell. Madam Hearing Officer, we uploaded an excerpt from OCD Exhibit 16 that was introduced during this rulemaking and would like to conduct Sir rebuttal on it. Yes, ma'am.
Thank you. Go ahead.
Mr. Everhart is pulled up. Can you see the excerpt from the spreadsheet?
I can.
There. Thank you. Now, did you listen to Mr. Powell's testimony?
No, I did not.
All right. Have you reviewed the portions of Exhibit 16 that pertain to Longfellow?
I have.
I want to ask you a couple of questions. First of all, and Mr. Everhart, it's just there at the bottom of your page, right above the pink. If you could zoom in just a little bit more. Could you tell us what those 3 wells just above, and pardon me, I'm a little bit colorblind, but I would call that pink, and there Mr. Everhart is kind of highlighting them for us. What
Sure.
wells are those?
So I don't see the well names, but those are saltwater disposal wells in our project. They're used to basically dispose of produced water that we don't have beneficial use for.
Okay. And what is the BOE reflected in that exhibit for each of those wells?
0.
And what are the production days?
0.
Would you expect the OCD records to show no BOE and no production days for those wells?
Yeah, those wells are not producers. Those wells are injectors. They're used for essentially disposing of produced water into approved formations. When you produce oil and gas, you produce water along with it. That water has to go somewhere. We recycle a large amount of water for ongoing completions operations. But whatever excess water we have, we put into these 3 wells, and there's 2 other ones that we have in the project.
Thank you. Have you also looked at Exhibit 16 to try and figure out what the bonding requirements would be under this rulemaking for Longfellow?
So I have, and I'm not a lawyer, and for sure my interpretation is my own. But my understanding from looking at this list, and again understanding that we have about 25 wells that would classify as marginal wells. At $150,000 a well, that would be something approximating a $3.5 million bond.
And what percentage of your wells are marginal, on your understanding of this rulemaking?
On this list, it would be, I think it was 26. So 26%, and assuming we have about 100 wells, it would be about 26%.
Right. And have you attempted to determine what the cost would be to Longfellow if you had to bond all of them?
If we had to bond all of our wells, we'd be looking at something like $115 million.
All right. And how do you bond right now in New Mexico, and at what cost?
So we have, like I said, we have a bunch of different bonds, but if I speak generally to them, we bond through bonding surety companies, and they charge us. Well, it's actually gone up by about 50% in the last year or so, from 2% to 3%. If we had to bond this incremental 15 million, the likelihood is that would go up, and there would be a cash posting requirement associated with that larger bond that we would have to bear.
What would it mean if Longfellow, if it was having to spend that money on bonding?
I mean, it'd be extremely meaningful. We have I mean, for us, we have, we're not a big company. We operate out of cash flow. We try to manage, we had very low debt levels of debt. If we had to put, let's say $10 million to bonding, that would be money that we wouldn't be able to invest in development.
And does Longfellow intend to continue developing?
Absolutely. We've drilled about 40 horizontals to date. We have another 100 approximately in our forecast over the next 5 years.
Thank you for your testimony, Mr. Mitchell. Madam Hearing Officer, I move to admit the direct testimony of Mr. Mitchell and the demonstrative 4 pages of demonstrative exhibits that we have used.
Thank you, Mr. Cloutier. I'll pause for a moment in the event there are objections. Okay, they're admitted. Thank you.
Good. You can take it down.
Is he ready for questions?
We're past the witness,
All right,
Madam Hearing
thank you.
Officer. Sorry.
Just a reminder, because Mr. Mitchell was offered as a fact witness and kept his testimony within 30 minutes, cross-examined by every other party is limited to 15. Ms. Fox or Mr. Tisdale?
No questions, Madam Hearing Officer.
All right, Mr. Tremaine or Mr. Hall?
Mr. Tremaine this time. All right. That's good. All right. Mr. Mitchell, thank you for being here this afternoon. My name is Jesse Tremaine. I'm the legal director for the Oil Conservation Division.
Nice to meet you.
Excellent to meet you. I just want to ask a couple clarifying questions. You referred to Exhibit 16 as to rebuttal. Are you aware that Exhibit 16 is an export of production and injection data from OCD permitting?
Yes.
And do you agree that production and injection data in OCD permitting is reliant on the C-115 reports, which are filed exclusively by operators?
Yes.
Okay. Do you understand that injection wells fall under Part 20 of the New Mexico Administrative Code?
I'm not familiar with the code, but
I'll rephrase. I'm not trying to, that was poorly phrased, sorry. I'm not trying to ask you to make a legal conclusion. But is it consistent with your understanding that injection wells, so specifically produced water, saltwater disposal wells, require an underground injection control permit from OCD?
Yes.
Okay. And is it your contention in making your testimony that UIC permitted wells are bonded in the same way as production wells in New Mexico?
I'm not sure. We do have separate bonds for our injection wells than we have bonds for our injection wells. So I'm not sure if that's the question.
All right. You have separate bonds for your injection wells because the bonding for injection wells is required under the specific permit for each injection well, correct?
I'm not sure. I'd have to talk to our regulatory folks about that.
Would that be something that you would want to check in on before continuing with the assertion that your injection wells are going to require single well financial assurance of $150,000?
I don't think it meaningfully impacts
that
my...
mischaracterizes the testimony. We did not count the injection wells in the count of potential marginal wells. The point of mentioning it was different.
All right.
I'm pretty sure you just testified that they were concerned that those would fall into the marginal well category.
That's what I thought.
I think what the concern that was expressed was that the exhibit contained 0 BOE and 0 production days and might have been counted as, for instance, he doesn't know this, but might have been counted by Mr. Powell in the wells that he still considered non-beneficial use. That was the purpose. He testified as to 26 marginal wells, which is separate and apart from the saltwater disposal wells.
I do remember he said 0 BOE.
Okay. Well, I'll let the record reflect what the record reflects. I have no further questions for Mr. Mitchell. Thank you very much.
All right. Thank you, Mr. Tremaine. Mr. Moore?
Madam Hearing Officer, it's actually going to be me if I'm,
Oh, thank you,
next. We're next.
Mr. Birnoff. Thank you.
Thank you, Madam Hearing Officer. Good afternoon, Mr. Mitchell. I think we've had a little bit of email contact, but I don't think we've met before. Do I have this right? In your direct, did you testify that Longfellow would need to bond in the amount of around $3.5 million for marginal wells if the proposed rule was implemented, was promulgated?
As I understand it, yes.
Okay, and how many wells are in that category? How many Longfellow wells are in that category?
We have about 20 wells that would fall into that category. And so the 3.5 million is an estimate at 150,000 per well times 20 wells is how I got to that number.
Has Longfellow studied or determined the present day plugging and remediation site cleanup costs for those 20 or so marginal wells?
We definitely, we recently P&A'd a well. So our P&A costs are fairly fresh associated with one of these type of wells. These are shallow wells. They're about 4,000 feet true vertical depth. And that cost us, I think, just around $30,000 to plug, maybe a little bit less. Now the remediation aspect, I don't have an estimate on that.
Okay, so Longfellow doesn't know as of today what it would cost to do surface cleanup at the sites of those 20 or so marginal wells. Is that right?
Objection. Mr. Mitchell is not being tendered as a representative of Longfellow or all its corporate knowledge.
Well, that's fair enough, Madam Hearing Officer. I can ask the witness about his own personal knowledge. We can leave it at that.
All right, go ahead.
Mr. Mitchell, do you personally know what it would cost for Longfellow to conduct surface cleanup, reclamation, remediation at the site of the 20 or so marginal wells?
We have not remediated any of the vertical wells that we own in New Mexico.
And have you studied or are you aware of any study by anyone else at Longfellow of what those costs would be, even though you haven't done the work yet?
No.
Okay. Do I have this right, Mr. Mitchell? Did you testify that if this proposed rule were promulgated, that Longfellow would need to bond in the amount of around 15 million for all of its wells in New Mexico?
So I think the way the question was asked was if I had to bond 100% of our wells, how much would it be? And if we have approximately 100 wells producing today, that would be at $150,000 a well. That's where the 15 million came from.
Okay, and has Longfellow, to your knowledge, determined what it would cost in today's dollars for Longfellow to plug all of the wells that it operates in the state of New Mexico?
No.
Okay, and has Longfellow studied or determined, to your knowledge, what it would cost for Longfellow to conduct surface cleanup at the site of all of its wells in the state of New Mexico?
No.
Thank you, sir. Pass the witness.
Thank you, Mr. Birnoff. Let's see, I don't believe we have Ms. Nanasi. Mr. Maxwell, do you have questions of Mr. Mitchell?
No questions. Thank you.
Thank you. Mr. Rankin, any questions?
No questions to the witness. Thank you, Madam Hearing Officer.
All right, EOG is monitoring. Mr. Suazo, do you have questions?
No questions from NMOGA for this witness.
All right, Mr. Cloutier, do you have any redirect?
I do not, Madam Hearing Officer, and I request that Mr. Mitchell be excused.
Commissioners might.
Oh, I apologize. I apologize, Commissioners. Mr. Mitchell, the Commissioners may have some questions for you. They'll probably be the smartest questions you get.
Commissioner Mpoma.
Thank you, sir, for your testimony today. I do have a few questions for you. So you were asked about the bond. Let's say how much you have to put if, let's say, you have 20 wells in the current definition of the marginal wells, and you said 3.5 million bond that will be required. and you do have about 26% of your wells in marginal category based on the current definition, which will mean that you have to bond all your entire wells to be the tune of $150 million. Now, I want to ask, what if the commission decides to go down to about 30%?
I'm sorry. Sorry, your volume stopped for a moment after you started to go into all of our wells. Could you please repeat?
Sorry. So all your wells, you will need about $150 million, as you've already testified to. So I'm asking, what if the commission, instead of the 15% threshold for operator to put a bond for all the entire wells is reduced to 30%? Would that alleviate some of your concerns?
You know, it's difficult to answer that, and the number I gave was 15 million, not 150, just for clarification. But it's difficult to understand. First of all, your question was broken up a fair bit, so I apologize. If it's possible, could you rephrase just the short version of the question?
So your $150 million required bond estimate is based on the fact that you do have 26% of your wells in marginal category. So I'm asking if the commission adapts 30% threshold, would that alleviate some of the concerns you have?
Not really. The simple fact of the matter is that as a percentage of total wells, it challenges operators because to make decisions that they otherwise would not make. So if I have just whatever number it is, let's just call it 30% of my wells are marginal. Does that mean I no longer can make new acquisitions for future development of new lands because that the wells that would come with it would put me, one well over the line, just as a simple example, and create 70% additional bonding requirement. The fact that there's this lever to some and then all, that's generally a very big challenge for us to understand, and it will put us in situations where we're either prematurely plugging wells that have beneficial that have production that we can harvest economically, just to stay below an otherwise arbitrary threshold to prevent that slingshot of all of your wells. And wells have lots of different uses. I mean, we have wells that like I said, those 3 wells, and I believe after some of the cross-examination, those wells were producers that we converted to saltwater disposal wells. And so we're taking something that had nominal value to our operation in terms of production, and we turned them into some assets that have huge value to sustaining the new wells that we're drilling and the production and water associated with those wells' production. And if groups are forced to make decisions prematurely to plug and abandon wells, the beneficial uses associated with not just the remaining production, but also future conversions to uphole recompletions or saltwater disposal, or if you think about the operations in all of the secondary and tertiary floods in the United States, those are all driven by vertical wells that were primarily producers in their early life that were converted into either water floods or CO2 floods down the road. So those thresholds that create an all, some or all, those are really the challenge. One of the challenges we have with some of the proposals that are being discussed.
So was it your testimony that for the surety bond, you probably be looking at 2 to 3% of the total cost?
Our current surety rate is 3%, but as your total aggregated bonds grow, so does the surety bond requirement. So it's uncertain if, for example, all of our wells needed to be bonded, what that rate would look like. The likelihood is it would be, we would have to post some sort of cash collateral, and there would be interest associated with that, plus the 3%. So you might be looking at something closer to 10%.
Wow. So if, let's say, assuming based on the current rules, you do have 150 million required bond that you have to acquire for all the wells that you have. So how much are we looking at in terms of the bonding amount that you have to pay for the surety bond?
Yep. And I do want to bring back, just to answer your question, to do 150,000 on the 100 wells would be 15 million. So the amount we'd be paying to the surety in the example I gave would be about $1.5 million a year.
And you could use that money to plug the wells?
Well, we could use that money for lots of things. We use it for either developing new wells or plugging wells as they move through their productive and useful life. But yeah, that money would be a meaningful reduction in our capital availability.
I mean, it's interesting though. So from your estimation, who are we helping here? Is it enriching the surety bond companies or, I mean, solving the problem?
I really think that the surety bonding companies are going to have a challenge meeting these regulations. We've already seen surety companies pulling back from not only New Mexico specifically, but really the oil and gas space in general as bonding requirements have changed over time. So there's a real possibility that bonds, the availability of bonding would be restricted to just the very large companies, which would effectively decimate the smaller companies and the mom and pops that are really the local kind of heroes of the small communities that we operate. So I don't know who the beneficiary would be here, but it would certainly create a real problem for the industry at large.
Thank you for your time, sir.
Thank you.
Commissioner Bloom, do you have questions of Mr. Mitchell?
I do, Madam Hearing Officer. Thank you. Mr. Mitchell, good afternoon. Thank you for your time. I represent the land office. Longfellow came by, I think, this past spring and talked to us about some of the things you're doing out in Loco Hills. And I think you told us today that you have taken production out at that development from 200 barrels a day to 6,000 barrels a day now. Is that correct?
Correct. It's probably a little higher than that, but yes.
Yeah, so I think that's a nice achievement, and we like to see that on our state trust lands because that money, the royalty revenue from there benefits our school kids and other beneficiaries. I'm here for the Commissioner of Public Lands, and so I think almost inextricably I see things through that lens at times. I'm also trying to having a wider view also. Something I've spoken to the legislature about is the bonding gap we have on state trust lands, and that was identified in a 2021 report by the Center for Advanced Research as being $6 billion with a B. And that's sizable. I mean, all the money that we've been able to make from oil and gas off of state trust lands since statehood is in the Land Grant Permanent Fund. And that's about $35 billion today. And so that bonding gap that's out there could be 1/6 of that. On the other side, I was asked to calculate this based on some questions we got at the legislature about what kind of income comes in from independence and how will certain activities affect independence. Independents pay royalties to the land office of $15 million a year out of $2.5 billion. So that's about half of 1% of our royalty income comes from independents. And we have a bonding gap of $6 billion. So this is what we're trying to negotiate up here. How do we protect the state and the taxpayers and beneficiaries and try to prevent waste, protect the environment, protect public health, water. When you see that delta in terms of income to the bonding gap, what are you hoping that the OCC does here?
Yeah, I'm an engineer. It's not really my place to recommend policy or regulation, and that's not really why I'm here today. It's a challenging position that you're in, and I understand the need for these discussions, but I'm really here to talk about kind of the operator view and anything that tips into the legal or regulatory recommendations is really outside of my expertise.
Well, sir, thank you so much for your time, Mr. Mitchell. Much appreciated. No further questions.
Chair Chang?
Thank you for your time, but no questions from me. Thank you.
All right, any reason not to excuse Mr. Mitchell? Thank you very much, Mr. Mitchell, for your testimony.
Thank you very much.
And Madam Hearing Officer, Ms. Tripp's prepared to call Mr. Hanagan, and our next witness, Mr. Sharp, is not available till 3, so suggest we take a break either before or after Mr. Hanagan, whatever your pleasure.
Sorry, let's take 10 minutes now. I just realized it's 2:25. So
Thank you, Madam
back
Hearing
at
Officer.
2:35.
Glad you're quarantine commissioner.
I'm not. I'm the worst guy, the worst cabin fever.
I'm Michael Hall, just to introduce myself. I don't know if you're ready to shake hands or anything. It's nice to meet you in person.
Okay. I see Ms. Tripp on the screen.
Yes, Madam Hearing Officer.
And
I
I
believe Ms. Apodaca is in the process of.
bringing up Mr. Hanagan.
Yes, ma'am.
All righty. Mr. Hanagan, can you unmute yourself? Maybe even turn on your camera?
You got me?
Yes, yes, thank you. Loud and clear. Would you spell your first and last name for the transcript, please?
It's Mike, M-I-K-E, Hanagan, H-A-N-A-G-A-N.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Tripp.
All right. Now, thank you, Mr. Hanagan. We've met a couple times. You know who I am. And you've already spelled your name, but can you let me restart that. You submitted some rebuttal testimony in this rulemaking. Do you recall that?
Yes, ma'am.
Okay. And do you have any changes or adopt it as is?
I believe we'll adopt it as is.
Okay. And can you introduce yourself to the commission in terms of your personal background, education?
I graduated with a degree in geology from Fort Lewis College in Durango in 1983. I've been employed either as an employee or an owner in the oil and gas industry in New Mexico since then.
And what companies have you worked for over your career?
I started with Marbob Energy, was with them quite a while. Then I went in with Monsanto Oil Corporation and then became an owner of Monsanto Oil Corporation. And then we started Monsanto LLC and then several different Monsanto Energy Corporation entities that were private equity backed entities.
And what is Monsanto LLC? How big is it? How many employees? What do y'all do in New Mexico?
We're an operating company. We have 11 employees that directly employed by us, and then numerous. We utilize third-party contractors for lots of stuff.
And so, in terms of the kind of drilling and exploration that Monsanto's been involved with, can you elaborate a bit on that?
Yeah, currently since 2008, we've drilled almost entirely horizontal wells, excluding a couple of disposal wells and maybe two at the most vertical wells, but almost all horizontal wells drilled in New Mexico and West Texas, San Andres Formation, Penn Shale, Canyon Shale, lots of Bone Spring.
And those 100 or some wells that you've drilled as a small company, do you operate those from beginning to end, or what's the typical transaction like for y'all?
Yeah, we especially since 2008, we've been backed by private equity capital, and so Monsanto is the operator of those wells. We'll put those deals together. Put land together, then we'll drill some wells to de-risk them. Monsanto will operate all those. Then we'll sell it to a larger company. So we'll operate from start through completion and production, but we normally do not develop the fields.
Because that development of the fields after you de-risk, that occurs with a larger operator. Is that right?
Correct.
Okay, so we've heard a lot, and your rebuttal testimony was responding to some of the points that Mr. Purvis made. And we've heard a lot about how 97% of production is in the top 10% of operators. And so do you have an opinion about that figure?
No, that's true. But a lot of those operators got their production from this 10% that found it and then sold it to them.
And in addition to drilling wells, has Monsanto plugged wells over its 40-year history in New Mexico?
Yeah, I believe we plugged 76 total.
And does
In New
Monsanto
Mexico.
have, I think you mentioned Texas. Can you talk a little bit about your operations in Texas?
Yeah, we're operating more and more all the time over in Texas. And we currently operate about 80 wells over there. We'll plug 3 to 5 wells a year there. And those are all horizontal wells, either Sprayberry or San Andreas.
And so when Mr. Purvis says there's no such thing as a small company drilling shale wells, well, Monsanto is a small company and you guys are drilling horizontal wells. Is that right?
That's correct. You don't get much smaller, and that's all we drill.
And in your perspective and your experience in New Mexico, the effects of this proposed rule, are you already starting to see that in the industry?
Yeah, I see it not only at my company, but I see it in properties that have been placed up for sale on the market. I know of 2 within the last 2 months that have not closed because of the it's not just because of the financial surety, it's the lack of confidence in what it's going to be, to assure to what they're going to have to bond if we bought some of these properties.
Would you consider, well, let me strike that. Another statement that you responded to, Mr. Purvis offered, was that that the companies who are affected by this rulemaking will be missed the least. But it's my understanding that small operators have a large role in New Mexico. Is that right?
I believe we do. I think we have had all during time a huge role in this state, and I know most people now apparently think that we will be missed the least, but I would say we won't.
And you've mentioned that Monsanto's gone through a couple iterations with private equity, and so to the extent that this rule was in effect back then, when you were taking on those projects, would it have changed the calculus, or whether you decided to invest and develop those fields?
Well, it's definitely changed the private equity outlook, although it's coming back now. But since 2008 to 2022, we had 4 iterations of our private equity company, and they were no longer interested in investing in New Mexico because of the uncertainty, the regulatory uncertainty. So, I mean, that was we've moved on and drilled projects since then, and it didn't put an end to us, but it put an end to them investing in this state.
And we've heard a fair bit of testimony about speculativeness and about risk during the rulemaking. Mr. Purvis offered the opinion that that small operators they're gambling. And does Monsanto gamble when you decide to develop a project?
Of course we do. That's been the history of the oil business.
But that gamble's not based on guesswork. You're relying on your experience and on information.
Oh yeah, it's an educated guess and we put 3D science in there, 3D seismic. I mean, we put a lot into it, but anybody tells you that this business isn't a gamble, it is.
That's fair. And I want for a second to talk a little bit more about the bonding. How is Monsanto currently bonded within the state?
With cash bonds.
And how many bonds are you currently required to carry, and are there any changes that are also affecting your operations?
Well, we have the state bond OCD plugging bond, then we have a bond with the state land office, and then we have a bond with the BLM. And all of these, of course, there's this rulemaking, and the state land office sent out proposals last week or week before last about increasing the bond to $150,000 per lease. I can't remember the exact specifics of it. And then we also got notice within the last month that our BLM bond would go up to $500,000.
And so, from a larger perspective, based on your experience in New Mexico and as a resident of New Mexico, what do you predict to be the ultimate outcome of adopting these rules?
Well, I know they're going to achieve what it is that they're trying to achieve, but they're going to destroy a lot in the process of doing it. And I'm not even sure it's going to achieve what they're trying to achieve.
I'm sorry to interrupt. Madam Hearing Officer, I apologize for the delay. I was having trouble with my buttons here. I'm going to object to the question and ask that the answer be stricken because it clearly calls for speculation on the part of the witness, which is something that the industry advocates have made a big deal about in this proceeding.
Ms. Tripp, there have been numerous objections about inviting speculation.
Yes, Madam Hearing Officer, but I'm asking him based on his experience in terms of operations within New Mexico, if single well bonding is applied at $150,000, how will that affect Monsanto's operations? And I can restate the question to follow that.
All right, or perhaps lay a better foundation for his ability to answer that question without speculating.
Absolutely. So Mr. Hanagan, I think we covered that you've worked in the oil and gas industry for the last 40 years. Is that right?
Yes, ma'am.
Okay. And then through those 40 years, have you seen changes in regulations?
Yes, ma'am.
Okay. And have you experienced the effects of those changes of regulations?
Yes, ma'am.
Okay. And to the extent that Monsanto would need to bond either marginal wells at 150,000 or plug wells because they're categorized as no beneficial use, how would that affect your operations?
Under our current well count, it wouldn't. Because I don't have any marginal wells, so I have a minimal number of wells right now.
I understand that. At a different time, when Monsanto was operating and you had more wells, would it change your analysis?
Yes, ma'am.
Okay, and how would it change?
It in all likelihood would drive me. It depends on which property it was, but it has the potential of driving me out of the state.
Okay, and I think the last piece with your testimony that responded to the Oil and Conservation Division, Mr. Justin Wrinkle, but I don't believe we need to revisit that based on the way the rulemaking's developed. But is it still your opinion that operators categorize expenses differently, whether it's CapEx or OpEx?
Yes, ma'am.
Okay. I have no further questions. I'll turn the witness over.
All right, thank you, Ms. Tripp. Ms. Fox or Mr. Tisdale?
Yeah, just a few questions, Madam Hearing Officer. Hello, Mr. Hanagan. My name is Kyle Tisdale. I'm an attorney with the Western Environmental Law Center and represent the applicants in this proceeding. How are you this afternoon?
I'm good, thank you.
Thanks. Just a few very short questions. Ms. Tripp was asking you or referencing your 40-year history as an operator in the state, and she also recognized that over those 40 years you have experienced several instances or many instances of new rules or regulations that have taken place over the course of that 40 years, correct?
Correct.
And in your experience as an operator, have you always been able to adjust to those changes in rules?
For the most part.
So you would characterize your operations as being in compliance with OCD rules as they have adjusted over the last 40 years?
Madam Hearing Officer, I'll object. I did not ask whether Monsanto was able to comply with regulations.
No,
And
that
that's
was
not
my
part of his
question, Ms.
rebuttal
Tripp.
testimony.
Yeah, that was my question, Ms. Tripp.
It's outside the
Yeah.
scope of the rebuttal testimony that was offered. That's my objection.
All right,
don't think so.
Mr. Tisdale, how is it related?
He's testified that over the course of his 40 years of operating in New Mexico, he's experienced many rule changes, and I'm asking whether he has been able to comply with those rule changes.
All right, go ahead.
Would you like me to restate the question, Mr. Hanagan?
No, I believe I've come into compliance with all of them. Some were harder than others.
Okay. And you also said that you have currently no wells in marginal status. Is that correct?
Correct.
And so therefore you have no wells also that would be presumed not to be in beneficial use under the proposed rules?
Correct.
Okay. Those are all the questions I have.
All right, thank you, Mr. Tisdale. Mr. Tremaine or Mr. Hall?
Mr. Tremaine, thank you, Madam Hearing Officer. Good afternoon, Mr. Hanagan. My name is Jesse Tremaine. I'm the Legal Director for the Oil Conservation Division, and we very much appreciate your time today. During your testimony, I believe you had indicated that Monsanto has been backed by private equity since 2008, correct?
Correct.
Okay, when I look at your operator file, it looks like you have about 5 wells now, and those wells are either in new status or they've been more recently drilled and brought into production. Is that a fair characterization of your portfolio?
As of now in New Mexico, I have 2 wells. I have 3 wells total on record. One of them's a marginal well and 2 of them are new wells.
Okay. In your testimony, you indicated that you were operating the Vince BGH #1, and during that period of time, you brought 2 new horizontal wells online, the Rag Mama 30-19 fee 1 and the Sod Buster 21 fee #4. Is that accurate?
I am no longer operating those, but at the time I operated those.
Right. Yeah, okay. You drilled them and you spud and completed those wells, correct?
Yes, the Rag Mama and the Sod Buster. I did not drill the vents.
Right. Thank you. Thank you. Are you able to recall how long the horizontals on the Rag Mama and the Sod Buster are?
They're both 1 mile laterals. One might be 1.25 miles.
Mile or 1.25 miles. Okay. Do you recall what the drilling completion costs were for the Rag Mama?
Yeah. The Rag Mama was a little over $4 million. It was a little more than the Sod Buster.
So the Sod Buster was a little less than 4 million, or how would you characterize
Correct.
that?
Yeah,
Okay.
that's just roughly on both of them, within $1 million.
Okay. A couple questions on the Vince BGH #1. I pulled up the well file just to kind of clarify here. And I'm going to, looks like we've gotten kicked out one moment. I'm going to join. And then when that works, okay. I'm going to share my screen. All right. Mr. Hanagan, I'm going to allow me to scroll up here. Don't want to start in the middle. All right. This is the OCD permitting well file for the Vince BGH #1. So just for the record, did you transfer from Monsanto, this well from Monsanto to Ad Astra Resources?
I did.
Okay. Really just making sure we're on the same page here. I want to jump down to, I'm clicking on the production here. And when we look at the production history for this well, if you look in the production section, we see oil, gas, water, and days reported, right? And you had indicated in your testimony that there were approximately 5 years where this well would have fallen into a marginal well status. Do you agree?
I did testify to that.
Okay. And then I just want to draw your attention to 2011 and 2012. So in 2011, it looks like you produced 297 barrels of oil. I'll just skip over gas, and you produced for 80 days. But in 2012, you produced 2,999 barrels of oil and produced for 252 days. So from 2011 to 2012, you saw a significant bump in production on that well. What happened with the well, or what did you do to the well to increase the production in that time period?
Madam Hearing Officer, I'll object to the extent that Mr. Hanagan can remember what one well did 13 years ago. I'm happy to have him answer, but certainly we didn't examine him or proffer this in our rebuttal testimony.
Right, but he testified about its status. And Mr. Hanagan, if you don't remember, you can say you don't remember, but if you remember, please answer.
I don't remember, but I didn't even own the well at that time. It was operated by Yates Petroleum till late in the 2000 teens, if not the 20s. So I wasn't even the operator then, so I have no knowledge of that.
Okay. So Mr. Hanagan, I'll ask a different question. So to clarify, are you saying that the well that you operated at a later date would have been in marginal status while it was operated by a different operator?
I think so.
Okay. In your experience operating, drilling, completing, and producing numerous wells, would you expect a well to go from 297 barrels of oil in a year to almost 3,000 barrels in a year without performing some sort of work on that well?
I would not.
Madam Hearing Officer, that's the same objection for speculation that that's already been raised.
I think there's ample foundation for this question, but I'm moving on.
All right, thank you, Mr. Tremaine.
All right. So, Mr. Hanagan, later on, we see that in 2022, this well fell into down to less than 1,000 BOE. Actually, in 2021, sorry, fell down to less than 1,000 BOE, and you reported 0 days, and it remained below that threshold for the remainder of that well's active life. Right? Did you own or operate the well during this period of time in 2021 through 2025?
Yes.
Okay. Did you ultimately decide to, or did you ultimately perform the plugging on that well, or did Ad Astra plug that well?
That well hasn't been plugged. That was the whole purpose of that testimony. That well was converted to an injection well and is a pressure maintenance well at this time. The whole purpose was to show it as a use of a beneficial use of a well that had no value.
I see. Thank you very much for that clarification. So, so in 2021, that was, okay, that's the fifth year you were referring to. So in 2021, that well would have fallen into the marginal well category, correct?
Correct.
Okay, and then it was converted to injection. So, do you agree that when it was converted to injection, it would no longer fall into the marginal well category?
I don't know.
Okay.
I don't know. I don't know what category it falls into.
Do you agree that this well, if you have a well in this type of posture or production situation, and that you as a oil and gas developer, if you're going to do some sort of, you have a plan for that well, that you can apply to the division to put that well into approved temporary abandonment?
Do I know that you can do that?
Yes.
Yes.
Okay. So if you as an operator are looking at a well that's dropping off production and you want to do something with the well or you want to convert it to injection, you have viable options available to you to keep that well out of marginal status, don't you?
You may, you don't always.
Okay.
I did in this case.
So, Mr. Hanagan, you just testified that you operated this well in 2022 at the time it was converted. Was there something mechanically going on with that well that would have prevented you in 2022 from simply producing that well for more than 180 days?
Well, I wasn't making any money producing whatever I was making at that time.
Okay, so you decided for business reasons to produce that well for less than 180 days during 2022.
Objection. I believe that misstates his testimony so far.
All right, I'll move on and pass the witness. Thank you, Madam Hearing Officer.
Okay, thank you, Mr. Tremaine. Mr. Biernoff, do you have questions of Mr. Hanagan?
Yes, I do, Your Honor, Madam Hearing Officer. Thank you. I'm just trying to get the camera back on. So thanks for bearing with me. Good afternoon, Mr. Hanagan. I'm Ari Biernoff. I'm an attorney for the State Land Office and Commissioner of Public Lands. I have a few questions for you. You established with Mr. Tremaine, the prior attorney who was asking you questions, that Manzano operates, I think it's 5 wells in the state of New Mexico. Is that right?
No, I stated it's 3.
Oh, it's 3. Okay. I inflated it by accident. So you're operating 3 wells now, and I think you testified in response to one of Ms. Tripp's questions that Manzano has plugged something around 70 wells, maybe more. Is that right?
I believe we identified 76 somewhere.
76 wells. Okay. And so does Manzano, is it fair to say that Manzano has a smaller operational footprint in New Mexico than it did in the past?
Definitely.
Okay, and you're not taking the position that this proposed rule, which hasn't been adopted, is just being considered. You're not taking the position that this rule is what has shrunk Manzano's business, are you?
It is a large, this rule's been talked about for well over a year, and it is a big reason that
It is?
It is.
Okay, well, let's explore that a little bit. A year ago, when this rule was first being talked about, how many wells was Manzano operating in New Mexico?
Probably 25.
Okay, and is it your testimony that because of the possibility of this rule being introduced, being petitioned, possibly being promulgated in some form, that is why Manzano got rid of 22 of the wells that it used to operate a year ago?
That's not my testimony. My testimony is that the regulatory environment in New Mexico has made it conducive to do business elsewhere.
Did you profit from the transfer of any of those approximately 22 or 23 wells that you operated a year ago and don't operate today?
I do not profit from them. I sold them for less than they were making.
Okay, so you took a loss to get rid of 20 plus wells simply because this rule was being talked about? Is that your testimony?
Again, it was not my testimony, and it was not just this rule. It's the overall regulatory environment in New Mexico towards the oil and gas industry that's just made it more conducive and profitable to go elsewhere.
Mr. Hanagan, you mentioned in your direct testimony that I think you said there were 2 transactions that you knew about, and I wasn't clear on whether those were Manzano involved or not. But there were 2 transactions that didn't close because of the specter of this rule. Did I get that right?
It was because of the uncertainty of total financial assurance and the cost of transferring what it was going to cost to transfer a lot of those wells in there, and then how many of those would fall under this rule. I'm aware of 2 transactions that did not close.
And were those transactions that involved Monsanto as a party?
They were not.
Who did they involve? What transactions were they?
I was under a confidentiality agreement when I reviewed them.
Madam Hearing Officer, I'm going to ask that Mr. Hanagan's testimony about undisclosed, unspecified transactions be disregarded. There's no reliability here if we don't get details on what these supposed transactions were.
All right, thank you, Mr. Biernoff. I believe the commission can certainly consider Mr. Hanagan's testimony and give it the weight that is appropriate to give it. So I'm not going to dismiss it, but they'll certainly be advised as to weight.
Mr. Hanagan, are you involved in an ownership or management capacity, an entity called Hanagan and Hanagan?
Well, indirectly, it was dissolved back in the 60s or 70s.
Okay, so Hanagan and Hanagan, that entity that was dissolved in the 60s or 70s, that doesn't have any ongoing commercial interest as far as you know?
No, it was owned by my dad and my uncle, and they never did business, and they're both dead, and they did not do any business under Hanagan and Hanagan since, I think, the late 60s, but without a doubt, the late 70s.
Okay, and what about Hanagan Petroleum Corporation? Is that an entity that you're involved with in an ownership or management capacity?
Madam Hearing Officer, I'm going to object to this line of questioning. Mr. Hanagan's here to testify about his role with Monsanto LLC and his personal knowledge and experience in the industry. We haven't examined or attacked credibility of witnesses with any other witness that's appeared in this rulemaking. I think it's improper in this venue.
Madam Hearing Officer, there's nothing improper about determining whether this witness is involved not only in the business affairs of the company that Ms. Tripp cherry-picked to have him talk about, but also in other entities that may or may not be involved, that he may or may not be involved in. If he's not involved with them, we can move on. But if he is involved with them, the compliance problems, including failure to bond, that those companies have experienced is a suitable line of inquiry.
I agree, Ms. Tripp. Go ahead, Mr. Biernoff.
Mr. Hanagan, I was asking, do you have any ownership or management involvement in Hanagan Petroleum Corporation or Hanagan Petroleum Company?
Hanagan Petroleum Corporation, I am the president of.
Okay. And does Hanagan Petroleum operate any wells in New Mexico?
They do not.
Okay, and so therefore Hanagan Petroleum has no reason at this point in time to post a bond with the Oil Conservation Division. Is that right?
They do not, but I believe they have one.
Okay. Thank you very much, Mr. Hanagan.
All right, thank you, Mr. Biernoff. Let's see. I don't think we have Ms. Nanasi. Mr. Maxwell, do you have questions? May have stepped away. Mr. Rankin, do you have questions?
No questions, thank you.
Okay, thank you, Mr. Maxwell. Mr. Rankin, do you have questions?
Madam Hearing Officer, I don't have any questions of Mr. Hanagan. Thank you.
Okay, EOG is monitoring. Mr. Suazo, do you have questions?
Namoga has no questions for this witness, Madam Hearing Officer.
All right, Ms. Tripp, do you have redirect?
Yes, Madam Hearing Officer, just one real briefly. So Mr. Hanagan, Mr. Tremaine from the Oil Conservation Division asked you some questions about the vents pressure maintenance project. And I just thought it was interesting because obviously we cited that as a an example of repurposing an old vertical well, but what was the reason to repurpose, and how are you accomplishing that? Because it's not your typical pressure maintenance, water flood unit, anything like that.
Yeah, but so that well was definitely uneconomic. The two wells that were associated with it, the Rag Mama and the Sod Buster, were both high water producing wells, high water cut wells, and their production was decreasing. So it was a way to utilize the vents to both inject the water and maintain the reservoir pressure, which at the hearing before the state OCD on the project, we ended up showing that it did that indeed.
And so you've seen that project bear results, and in terms of increased production, better quality for those wells, and in other areas within New Mexico, some companies are using that same approach. Is that right?
You know, I can't speak to whether other companies are. I know other companies are using a similar approach to inject their gas when they have a plant go down or something under the new methane rules. You'd have to shut in within 8 hours. So they have gone to the trouble of converting some wells into gas injection wells where they can put that gas straight into the ground as opposed to shut them in.
Okay. All right. Thank you. That's all the questions I have. I really appreciate your time today.
All right.
Thank
Thanks.
you. Thank you, Ms. Tripp. Commissioner Ampoma, do you have questions of Mr. Hanagan?
No.
Commissioner Bloom?
Mr. Hannigan, thank you so much for your time today. I do not have any questions for you. Thanks again.
Okay, Chair Chang?
I don't have questions either. Thank you.
All right, if there's no reason not to excuse Mr. Hanagan, thank you very much, Mr. Hanagan.
Okie doke. Thank you.
And Madam Hearing Officer, IPANM's next witness will be Mr. George Sharp, and I believe he may be on the platform.
All right, thank you.
Indeed, I am here.
Great. Let's see.
How do you like my little Christmas tree over there?
Yes, we're going to pin you here. Mr. Sharp, would you spell your first and last name, please?
GeorgeSharpe.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Tripp.
All right, thank you, Mr. Sharp. So you've already spelled your name for the commission. You submitted some direct testimony in this rulemaking. Do you recall that?
I do.
Okay. And do you adopt that testimony today?
There is a change. When I initially made that testimony, I made the comment that the majority of Marion's wells are marginal wells, and the marginal status I was using was kind of an industry standard, IRS standard. Was not using the 1,000 BOE in 180 days. We actually only have 2 wells that are in that category.
Okay. And so to the extent that there's some testimony, you will be correcting it today while you testify in terms of there's 2 marginal wells under the current parameters.
2 wells that would require the $150,000 bonding.
Thank you. And so can you introduce yourself to the commission in terms of your education and experience?
I born and raised in Farmington, New Mexico, went to Colorado School of Mines, have a master's in petroleum engineering, worked for Chevron for close to 10 years, and in 1990 came to work for Marion Oil and Gas in Farmington, and have worked for Marion for the last 35 years. I am the investment manager for Marion. I'm an expert in economic analysis and valuations primarily.
And then, thank you. Can you explain a bit about Marion Oil and Gas? and their history with the state.
Sure. J. Greg Marion started, actually moved from Midland to Farmington in 1960 and mortgaged his house and drilled a well on some family-owned minerals, and luckily it hit. Through the years, he teamed up with Robert L. Bayless. They were Marion and Bayless for many, many years, and eventually that grew into Marion Oil and Gas. Marion Oil and Gas, Marion and Bayless, Marion Oil and Gas grew primarily through the acquisition of marginal wells for major companies. They did some drilling, but they would buy marginal wells, create an acreage position, and then maybe try to enhance that position. The reality is that Marion Oil and Gas would not be here today if the current rules were in place through our history. They may have been able to drill that first well, but they wouldn't have been able to make any of those acquisitions from the larger companies, wouldn't have been able to grow. And in fact, we're still a very, very small company within New Mexico. We have, when the shale plays came into vogue, our annual budget won't drill more than 1 or 2 shale wells. And so we started buying minerals in other shale basins and started most recently investing in non-operated drilling opportunities also in other basins. There are opponents, oil and gas opponents, who will argue that if Marion Oil and Gas had never been created or were gone today, the state of New Mexico wouldn't even notice. Wouldn't affect the production, more than a fraction of a percent, and it wouldn't matter whatsoever. That is true. It would not make a difference necessarily to the state. But I want to talk about the kind of a citizen that Marion Oil and Gas is. And is there? Am I allowed to share my screen?
I believe Ms. Apodaca, does he have that ability? The only caveat, Mr. Sharp, is that we haven't circulated any exhibits. But if there's no objection,
I just want to when T. Greg, so J. Greg passed away, I don't know, 10, 15 years ago. T. Greg Marion, who's my peer, retired in 2022. And when he retired, I kind of put a summary of all the impact that Marion Oil and Gas has had within the city of Farmington over the last 20 to 30 years. And it's tens of millions of dollars. T. Greg himself has been involved in, dozens of boards. And so while the state of New Mexico might not notice if Marion Oil and Gas went away, I guarantee you the city of Farmington would notice if Marion Oil and Gas went away. Our 20 employees would notice if Marion Oil and Gas was not here. And the dozens and dozens of contractors that we use to work on our wells would notice if Marion Oil and Gas wasn't here. And so that is one of the comments that I've seen from the proponents of the rule, is that it's really, not going to have much an effect on the state. Well, I beg to differ. There are lots of people that it's going to affect. And so if I don't need to show those slides necessarily, but I wouldn't mind submitting them as evidence.
Yes, Mr. Sharp, I believe even witnesses are allowed to submit public comment, and so we can accomplish that in that format. In terms of the wells that Marion Oil and Gas operates currently, and I'm sorry if I missed it and you already said it, about how many wells and what kind of depth wells are you operating?
So Marion Oil and Gas operates just over 100 wells in Wyoming, Colorado, and New Mexico. 66 of which are in New Mexico. We were in several hundred non-operated wells, and again have minerals and overrides and others. But of the 66 wells that are in New Mexico, they are primarily marginal, by my definition,
marginal gas wells, Picture Cliff, Fruitland Coal, Mesa Verde, and Dakota Sands. Our average well in New Mexico makes less than 20 MCF a day of our 60 wells. 65% of our wells made less than $15,000 in net profit in 2024. And if those wells were required to post the $150,000 bond, which at this point, not all of them will be required to do that, but they'd have to be, I mean, they couldn't afford to pay a surety, 10%. A surety bond is going to cost you 10% per year. They wouldn't afford it. And again, you can say, well, you aren't making much money on those wells. Anyway, it's not going to make a difference. But those wells have operating expenses of close to $1 million a year. They have pipeline expenses of $300,000 a year. They pay royalties of $150,000 a year. And so even though Marion's not making much money, there are a lot of people and a lot of jobs and a lot of things that are supported by those wells that are barely getting by. And those wells are important to Marion, and they're certainly important to the people that work on those wells.
And then in addition to operating wells, does Marion have a history of plugging wells or any experience with that?
Marion has plugged 144 wells across all states. We plug more wells than we currently operate. We plug a handful of wells every year in various states. And again, we try not to let our wells languish and try to either keep them producing or plug them out.
And I'm not sure if you've been attending any of the testimony of the rulemaking. We did see Marion cited by Deputy Director Powell as an example of a great operator in New Mexico, but he highlighted one well for the commission to look at, which was the Farmington CCOM, which reported a really low production last year. Have you had a chance to review that well specifically? Do you know anything about its background?
I do. The Farmington CCOM well was initially a Dakota well. It was plugged back and completed in the Picture Cliff and Fruitland Coal. The Picture Cliff and Fruitland Coal zones have been depleted, and it is on our list to go in and pull out or drill out the bridge plug and try to go back to the Dakota, which was making 60 MCF a day at the time it was recompleted to the Picture Cliff. And so that's better than our average well, So no, we definitely have plans to return that well to production. And through, it hasn't happened over the last several years. Prices look like they're going to be up for a little bit. And then, just like this last year, they've been below 3 again. So it's been very difficult in the price environment. We're hopeful that 2026 will have sustained prices high enough to justify a workover on that well to get it back on.
And when you talk about the factors that you're considering in terms of how to work over a well and when to do it, certainly Marion's the operator for a well, but does Marion own 100% of the interest in every well it operates?
We own an average of 50% of the working interest in the wells we operate. The Farmington C, I believe we own a larger piece of that. I don't know off the top of my head. We do have some partners in it, but we own 80 or 90% of the Farmington C.
And so the decisions about whether and when to work over is that decision subject to any outside agreements or contracts?
Not necessarily.
Or a joint. Oh, go ahead.
Well, they're all under joint operating agreements where we've got to get approval from partners to do the work. But if the partners don't approve it, we can take them non-consent and do it ourselves. And so no, there's no really, it hadn't been the partners that have kept us from getting the Farmington C back on production. It's just been economics. Okay. Economics and budget and timing.
Mm-hmm. And then in terms of, you mentioned how many wells Marion had plugged over its career. Does the presence or the existence of a plugging bond, does that motivate or affect your decision whether to plug a well?
No, at least it hadn't heretofore. I mean, we have right now, we've got statewide bonds, you know, and so whether we plug a well or don't plug a well, or statewide bond, you know, really doesn't change much. As my understanding. I'm not an expert on our bonds. I am aware of our bonds.
Mm-hmm. And to the extent, are you familiar with the term forced plugging, or where a company would plug a well that it is not operating?
Yeah, well, we are, thank you for bringing that up. We're in the middle of plugging a well right now. Actually, I think it has been plugged. We still have the surface rehabilitation to do, but it was one of the M&M wells that was orphaned, and we were in record title. It's a federal well, and we were the 50% record title holder, and so they've come to Marion and required us to plug it, even though the other 50% record title holders is like 20 other individuals, small individuals, and many of those aren't paying the bill. So Marion's paying the full bill to plug the well for M&M. We don't have access to their bonding that they had to cover their wells. So yes, we have, this is the first well that we've been forced to plug, but we're very concerned about being forced on other situations to do so.
So, you know, we've heard a lot about orphan wells in New Mexico. Would you consider there to be an orphan well problem or a crisis affecting the industry at this moment?
No, I don't consider it. I've looked at the list of the 1,800 wells that are on the state's orphan well list, and the vast majority of those are legacy wells that occurred, you know, well before the current regulatory environment that has been, you know, again, to the state's, you know, the state has really stepped up its compliance on wells that are shut in, either requiring them to be TNA'd or be produced or whatever, and so they've stayed on top of that. And that is so the problem is, I say the problem, you know, I don't think the problem is growing at any kind of a rate that cannot be managed with the current bonding setup, and that the industry, you know, again, what the opponents of oil and gas, you know, want to make sure that the state doesn't hold the bag, so to speak, for the cost of, you know, plugging these orphan wells, and that the industry ultimately would, you know, pay for the wells. And the industry is paying for their wells. The industry is the state. The industry contributes more than $15 billion in 2024 to the state of New Mexico. And so to the extent that the state, you know, has some wells that they're going to have to find money to plug, it's coming from the oil and gas industry. The second point is that the oil and gas conservation tax that was put in place specifically to create money.
Objection, Madam Hearing Officer. I have to, I've been letting Mr. Sharp go on, but this is well outside the scope of the proffered testimony. I'm trying not to object, but we're getting far afield.
Yeah.
Okay,
Sorry,
so-
Mr.
Yes,
I
I'm
think it
hearing
is far afield.
So, Mr. Sharp, to bring you back to the proposed rule and the surety requirements, are you familiar with the increase in financial assurance?
I am.
Okay. And in looking at how is Marion currently bonded? What kind of form do you use?
I guess I'd like to address the question as to whether that additional surety is needed or not. And if they use the oil and gas conservation tax for its intended purposes,
Objection.
then using
Objection.
it.
Witness is trying to answer the question that I objected to and which was sustained.
Right. Ms. Tripp, you really,
Okay.
he needs to stick with his pre-filed testimony.
Thank you, ma'am. So how is Marion currently bonded? Is it a cash bond or a surety bond that Marion uses?
So Marion has $1.5 million in cash bonds in place in Colorado, Wyoming, and New Mexico. We have a $150,000 nationwide bond that's due to be released because the 1.5 million is a recent. We've recently been required to do that. We have a small right-of-way damage bond in New Mexico, and we have blanket New Mexico plugging bond as well, also a cash bond in a CD.
And so if this rule is adopted and financial assurance is increased for marginal wells, do you anticipate an effect on Marion?
I do anticipate an effect on Marion. The first effect is that we're going to have a hard time doing what we've done through our life, and that is to, buy wells that are uneconomic to major operators and that those operators are going to be either the rules are going to prohibit it, or because of the threat of the rules, those operators are going to be reticent to sell to us. So that's going to be a major effect. To the fact that we've got to, post $150,000 for our first 2 wells. Again, that's a cash flow impact, and negatively affects our ability to use that money for helping to grow our company.
And then you've also offered some testimony about plugging costs, and we've already referred to the fact that Marion has plugged a lot of its wells, and that Marion's wells are generally in the shallower formations. And so what kinds of plugging costs does Marion see?
I just went through, we see plugging costs from the mid 30s to, we have some wells that we estimate are going to cost over $100,000 to plug. But I just analyzed our average. Let me find that. So we have in New Mexico, we have 153 zones. So that's a completed interval. So we have a lot of commingle wells, Gallup Dakota wells or whatever, and we track each zone on its own. The average plugging cost, we account for the plugging costs in our internal valuation of reserves every year. We plan on having to plug those wells. Our average estimated cost is $52,000 for each of those zones. And again, it ranges from $30,000 ish for shallow Picture Cliff, Mesa Verde wells to, $75,000, $80,000 for Mesa Verde Dakota wells.
Okay, thank you. Now, let me see. So you presented direct testimony, and then there was an opportunity for other witnesses to provide rebuttal. Have you reviewed any of that rebuttal testimony as it pertains to your own?
Remind me, I did the one, but I can't, it's not on the top of my head right now. I think it was just you talked about the Farmington C, Calm well, and I have reviewed it, but it's not coming in off the top of my head.
So Mr. Purvis, it took issue with your testimony that responsible operators plug wells and that the proposed rule changes were unnecessary. And he stated at Exhibit 74, page 7, line 20, that this argument is pure opinion, subjective, and anecdotal, and it's not a suitable basis to deal with a multi-billion-dollar risk. Now, Mr. Sharp, we've met several times, and you strike me as somebody who's interested in the data. And so, since you submitted your direct testimony in response to the allegation that it was pure opinion, subjective, and anecdotal, have you made any analysis or made any analysis of the data that's available in this rulemaking?
Thank you. I have. I've looked at the plugging list.
Objection, Madam Hearing Officer.
Hold on, Mr. Sharp. Ms. Fox?
Mr. Sharp didn't submit rebuttal. And if this is Sir rebuttal, then the specific testimony, the specific rebuttal testimony needs to be identified and then responded to.
Ms. Sharp, would you please identify the rebuttal testimony he's responding to?
Yes, Madam Hearing Officer. I'll repeat again the citation to Mr. Purvis's testimony. That's Exhibit 74, Applicant's Exhibit 74, page 7, line 20, where Mr. Purvis states that Mr. Sharp's argument is pure opinion, subjective, and anecdotal, and not a suitable basis to deal with a multi-billion-dollar risk. And so I think, is that sufficient?
Thank you. If that's what Mr. Sharp is referring to, yes.
Yes, go ahead, Mr. Sharp. You're referring to the master orphan spreadsheet
that
was
the
provided by
master
OCD?
Spreadsheet, and whether, who the bad actors have been and whether most operators are doing what they need to do. Of the operators identified on the master list, most of those have been out of business for years. They don't show up in Enverus. They don't exist. The most of the wells are legacy wells that again have been on the orphan list for years. Haven't been plugged by the state, even though they have, they're the ones that have been negligent in addressing that issue and using the funds that are already available to address that issue. And less than 100, as far as I can tell, of the wells actually have been added to the list in the last few years, indicating that most operators are not orphaning their wells. Most operators are operating their wells prudently and plugging their wells when they need to be plugged.
Okay. Thank you, Mr. Sharp. I don't have any further questions, but I turn the witness over.
All right, thank you very much. Ms. Fox, do you have questions?
Thank you, Madam Hearing Officer. Just a couple. Hello, Mr. Sharp. My name is Tanis Fox, and I'm a lawyer with Western Environmental Law Center, and I represent applicants in this proceeding. And I just have a couple. Can you hear me?
I can.
Oh, great. You began your testimony stating that you had a correction to your testimony based on the fact that you had misunderstood the definition of marginal well in this proceeding, correct?
That is correct.
And I'm looking at page 4 of your written direct testimony. And what was the marginal well definition that you were relying upon for your direct testimony?
The IRS definition.
I'm sorry, go ahead.
The IRS definition.
And how does the IRS define marginal well?
I believe it's less than 15 BOE, or it's off the top of my head. I don't know. I don't remember exactly what I used, and I don't think I put a number of how many wells are marginal. I just said the vast majority are. And at 20 MCF a day, whatever the IRS definition is, our average well is definitely less than that marginal status.
So if the federal definition, IRS definition is 15 BOE, and the marginal well definition for purposes of this proceeding is on average 2.7 BOE, and there's a day operation of day limitation too as well. The marginal well definition being used in this proceeding is significantly lower than the marginal well definition you were originally using, correct?
I understand that.
Yeah, but I'm correct in what I just asked you, right? It's significantly lower.
Significantly.
So then that testimony, Madam Hearing Officer, appears on page 4, going into page 5 of his testimony, just for the record, because you estimated that Marion would need to finance an additional $9.45 million in bonding, correct?
Had I been accurate, yes.
No, but that is what your incorrect estimate was.
That is my incorrect estimate.
And what was the basis of your misunderstanding of what the definition of marginal well was for purposes of this proceeding?
Just again, my own fault, being a lack of digging in and trying to clarify with the New Mexico oil and gas attorneys before, and not a full understanding of the rule. I'd read summaries of the rule. I had not read, I honestly still haven't read the full rule word for word. I've read analyses and summaries of it.
Sure. Now, you said that understanding now what the definition is for marginal well, you said that Marianne has 2 marginal wells in its portfolio, correct?
Yes.
So that would mean an additional $300,000 in financial assurance that Marion would need to put up for those 2 marginal wells, correct?
At this point in time, you're right.
And then there's been testimony from industry witnesses in this proceeding that the amount of money that you would actually, that a company, an operator would actually have to put up for a particular bond is in the range of 2 to 3%. And so if, let's just use 3%. So if you had to put up a premium of 3% for the $300,000, that would be an additional $9,000 per year that Marion would need to put up as a result of if the rules as proposed were adopted by this commission, correct?
That is not correct. Surety bonds cost 10%, or at least that's what was quoted to Marion. So it'd be $30,000 a year.
Okay.
For the surety bond. But the biggest deal is it'd be $15,000 per year on top of those wells. That's just going to make it that much harder to justify spending money on those wells and returning them to production.
These wells are in production.
Return
They're marginal wells. They're in production, correct?
Well, we produce a little bit we still squeak a little bit of gas out of the PC and the fruit and coal, but I mean, it's uneconomic and needs to be recompleted into we need to get the Dakota back on the Farmington CCOM in any case. And the other well that is marginal has a pumping unit that, and I'm not sure operations told me today, it's either a pumping unit or downhole problem, but basically it's producing by flowing a little bit of gas up the casing.
You, on one of your slides, I believe that you said Marion started in 1981. Is that correct? Or maybe it was in your testimony.
Marion Oil and Gas was formed in 1981 through Marion and Bayless that have been operating in Marion and Bayless. So basically, Marion has been in business since 1960.
And you said that if the rules as proposed here would have been in operation when Marion started, Marion wouldn't have been able to start, correct?
I mean, I think Jay Greg still would have been able to drill that first well, but their method of growth, their niche, if you will, as is the niche of many small operators, has been to take the wells that are no longer economic for majors to operate and to take those over and to cut costs and to make those work. Again, with
Whoops, he cut out. Convenient.
Mr. Sharp, you're frozen.
Are you back?
Oh,
Yeah,
sorry about that.
yes.
yeah, you cut out for a minute.
Yeah,
So let me, so you're changing your testimony then with respect to your testimony that said that if the rules as proposed were in effect when Marion came into business, Marion wouldn't have come into business. You're changing that testimony, correct?
Objection. I think that misstates his answer.
I mean, I don't. Whether Jay Greg would have, I think he probably still would have come up and drilled that well, but would they, would we be here today? I don't think we'd be here today. I guess that was my point. I think we'd have had to go away long before this.
And when you say you're referring to the rules as proposed, are you saying that the rules as proposed with today's dollars, if rules requiring bonding at $150,000 in the 1960s would have been in effect, that would have affected either the business initiation or ongoing operations, or is that what you're saying?
Absolutely.
Is that your testimony?
Yes, it is.
Is he cutting out again?
No, that is my testimony.
Okay. Oh, your hypothesis is that if the rules as proposed in the 1960s or 1981 proposed $150,000 bond, Marion wouldn't have come into effect, or it would have changed its business operations. Is that what you're saying?
It's not just the $150,000 bond. It's the limitation on being able to transfer wells or convey wells or assign wells from large operators to small independents.
Okay. Thank you. And then just one other point, Madam Hearing Officer, Ms. Tripp said that they would submit documents from Mr. Sharp as part of public comment, but I think as a witness, if he is going to present written documentation, he needed to have done that through his testimony.
Yeah, I think, Ms. Tripp, that there were deadlines even for fact witnesses
Yes,
here.
ma'am. Yes, Madam Hearing Officer. I wasn't not him as a witness.
Okay, thank you. Let's see.
Thank you, Mr. Sharp.
Yes, Ms. Fox, thank you, Mr. Sharp. There will be other questions, I believe, from other parties, but we need a 10-minute break before the 4 o'clock public comment. So, Mr. Sharp, can you stay on the platform for a little bit longer?
I sure can. How long? Like till 4:30, or I guess how long do public comments go?
I don't believe we're going to have a lot of public comment today. I had only one person actually sign up. There might be someone else, but it won't be very long, the interruption.
Okay.
Thank you. Break, please. Let's come back from the break, please. It is 4:00. We've reached another public comment session. I believe I see someone in the room who might be wanting to offer public comment. Yes, sir. Great. Come on up to the witness stand if you would. And just a couple of things. I'm going to ask you to spell your first and last name for the transcript, ask you to swear or affirm to tell the truth, and then ask you to keep your comments to about 3 minutes. So if you would spell your first and last name.
Glenn, Glenn, Weichel, Wikle.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Good afternoon, commissioners. Oil and gas is a boom and bust industry. Bust times are devastating for the industry and even worse for New Mexicans who rely on the industry for their livelihood. We all know the big bust is coming eventually. Either the hydrocarbon reserves will be depleted or new energy sources like renewables or fusion power will make hydrocarbons obsolete. The devastation of that big final bust will drive many oil and gas companies out of business. Operators will walk away from their leases en masse without cleaning up. We already have a case study from the big bust in the uranium industry. Our state is struggling to fund the billions of dollars required to remediate the damage caused by that industry. And that industry was much, much smaller than oil and gas. Today, the state's Legislative Finance Committee believes that the state's exposure for environmental cleanup of oil and gas wells is $1 billion. By the time industry finally pulls out, it could grow to tens of billions. Building oil pads and their access roads, as well as extracting and emitting toxic chemicals from the earth for profit, is a privilege that we, the people, grant to the oil and gas operators. In exchange for this right, they must clean up their messes. They must restore our land, water, and air to its natural state when they're done. Adults in this world are responsible for cleaning up their messes, period. If the industry policed its own members to do their part, then there would be no need for assurance bonds. But industry has failed to act responsibly. This leaves the state to finish the job. Industry points out that they are taxed to pay for reclamation. The legislature should direct all money in the reclamation fund to be used for oil and gas reclamation. However, the argument that this would provide sufficient funds for plugging wells is a red herring, and the oil and gas industry knows that. They know that reclamation funds also cover the cleanup of environmental damage caused by operators at facilities that have no wells. The taxes which go into the reclamation fund are also insufficient to cover those other environmental messes caused by the industry.